Honorable Senators, petition to the Senate by Mr. Taratisio Kawe regarding proposal to amend Article 47 and 49 of the Constitution of Kenya 2010 under the Bill of Rights and other laws relating to criminal offenses. Honorable Senators, I hereby report to the Senate that a petition has been submitted through the clerk by Mr. Taratisio Ireri Kawe regarding a proposal to amend Article 47 and 49 of the Constitution of Kenya 2010 under the Bill of Rights and other laws relating to criminal offenses. As you are aware, Article 119(1) of the Constitution states, and I quote, "Every person has a right to petition Parliament to consider any matter within its authority, including enacting, amending, or repealing legislation." Honorable Senators, the salient issues raised in the petition are that there has been a high number of extrajudicial killings and murders purportedly conducted by government agencies, that the state of insecurity in Kenya has continued to deteriorate, rendering security agencies and the people of Kenya frustrated, hopeless, and helpless. That the law should recognize and provide clarity on the nature of criminal cases, the bonds and bails terms, the punishment and the time frame under which the cases should be concluded in courts. That crimes such as murder, rape, robbery with violence, abduction should be investigated when the suspects or the accused persons are in custody and awaiting trial. That Article 47 and 49 of Chapter 4 of the Constitution were introduced to tame the frequent abuse of rights by previous governments on issues to do with arrest and detention of suspects without trial. However, there is need to amend Article 49(1)(f), Roman 1 and 2 to increase the duration of which the suspects are held in custody to allow for comprehensive investigations. That Section 25 of Evidence Act Cap 63 of the laws of Kenya is ambiguous on what constitutes a criminal offense. That most serial offenders have been released on bond, which has continued to encourage them to commit more serious offenses. This frustrates the security agencies mandated with investigations and the institution mandated with the prosecution of such cases, while on bond, rape and murder suspects end up threatening witnesses, thus shattering the window of justice. And that there is urgent need to amend the Constitution of Kenya on the Bill of Rights and other relevant laws, including the Penal Code and Anti-Corruption and Economic Crime Act, the Evidence Act, the Criminal Procedure Code, Cap 75, among others, that govern the judicial system and dispensation of justice, to provide for the threshold of criminal offenses and the duration of their conclusion in courts. The petitioners therefore pray that the Senate intervenes with a view to 1. Amending Article 49(1)(f), Roman 1 and 2 of Chapter 4 of the Constitution of Kenya by introducing a classification of types of offenses and a maximum number of days a suspect of specific offenses is held in custody. 2. Amend Section 123(1) of the Crime Procedure Code, Cap 75, to provide the perpetrators of offenses such as theft of public funds, corruption, and fraud crimes should not be released on bail. 3, to amend relevant legislation to provide a precise time frame within which the judicial process should be concluded on criminal offences, and 4, to introduce any other laws that ensure justice prevails for victims of criminal offences. Honourable Senators, pursuant to Standing Order 231, I shall now allow comments, observations or clarifications in relation to the petition for not more than 30 minutes.
The fact that he has presented the petition to this House and not the other House is a clear demonstration that Kenyans have faith in the House of the Senate. But Mr. Speaker, the matters that Mr. Taratisio Kawe is raising in his petition are very, very fundamental issues that goes to the core of our Constitution 2010. To me, Mr. Speaker, the biggest gain that this country or Kenyans got in the Constitution 2010 is number 1, devolution, number 2, the Bill of Rights, Chapter 4. Mr. Speaker, the implication of what Mr. Kawe is proposing, to me, is the beginning of introduction of things like detention without trial and so forth. I was part of the team, although I was very young then, that fought for the second liberation of this country. I was detained, and I know the pain. I was put in, Mr. Speaker. Stayed in custody for a long time without being presented to court. The Constitution 2010 cured those malpractices. I thank you, Mr. Speaker.
The silver lining in this petition, Mr. Speaker, is that it presents with us an opportunity. I have thought for a while that actually JLAC needs to look at the whole regiment of laws on the criminal justice system, specifically with regards to a suspect being produced before court. You know, we remember how we cheered on the thing of Kamata Fridays, yet little did we know that actually our police officers were slowly entrenching it into practice. The unfortunate thing is that even the DPP himself has publicly spoken about this item, and I remember seeing him once, I think he was in Mombasa or somewhere, saying, what is the problem? Even when you are young, people used to be arrested and it would take 2 to 3 days. I think our colleagues who serve in JLAC, you owe it as a sense of duty to the country to clean up those laws. The many things that are being used by the executive to clamp down on the rights of various citizens, so that a criminal justice system is used to serve the only purpose for which it was intended, which is to ensure that if you're guilty, you go to jail. If you're innocent, you walk free. Nothing else in between. You know, we see this practice being inculcated slowly. Even the judiciary, unfortunately, has bought into this silly game, because I've seen magistrates of late begin to set very exorbitant bail terms. You know, 10 million, 20, 100. Yet to the best of my understanding, world over, Mr. Speaker, bail is only to guarantee your appearance in court. It has nothing to do with whether you are innocent or guilty. You know, but there is this line, if you go nowadays, you hear them read and say, oh, because of the amounts of money involved here, how have you reached to the case? Yet the point, Mr. Speaker, is about whether you are innocent or guilty. Therefore, I challenge our colleagues who serve in Justice and Legal Affairs Committee that please look into this petition, tell him the truth that this is not the place where we want our country to go back into, but look into some of these practices that are slowly creeping in back to our society, so that even if it means setting it by law on how much, you know, what's the procedure, minimum amount for setting bail, because I've listened to some of the magistrates speak to it and say it's not my duty, because a few of our colleagues here in Parliament, they have the duty that they represent some of these suspects. And I think I once had, I can't recall his name, but he challenged them and says, you are the lawmakers, go and make this a bit more clear to them, so that it no longer becomes an issue of punishing people. Otherwise, this can be used, you know, to clamp down on the rights which so many of our colleagues, both present and past, have paid with their blood and lives for us to live and enjoy the freedoms that are guaranteed. Therefore, Mr. Speaker, let us not just throw it away. Let's read and remember that actually he reminds us that we ought to have done this so that we don't have such petitions. Thank you, Mr. Speaker.
I agree with the petitioner that we need as a parliament to review the penal code because the penal code violates the Bill of Rights. So I think what we need to do is not to condemn the petitioner or to make, certain insinuation and says that that petition should be thrown out, but to look at the silent issues and go deeper in them. Where we can be able to assist, we assist. But where we cannot be able to assist, we tell them we are sorry. Because, of course, the right of an accused person to be brought before a court of law within 24 hours is one which we'll all defend. But we also have to figure out what happens. The petitioner is arguing that very many people who commit offenses and are out on bail continue committing offenses because of the duration of time that it takes for a matter to be concluded. And once the matter is dismissed in the lower court, there's an appeal process all the way to the Court of Appeal and all the way to the Supreme Court. So, Mr. Speaker, my view is very simple. Let us look at the issue that the petitioner is raising. Let us put ourselves in his shoes as an investigator. He's finding it very difficult for him to be able to carry out his tasks. So, Mr. Speaker, I hope that the Committee on JLAC will actually take time to look at, and they should get copies of the petition and look at the legislation that he is proposing for them to be amended. Finally, Mr. Speaker, on the issue of amendment of Chapter 4, I think before a petition is brought here, just like Senator Mutula has said, petition should be disqualified based on what the petitioner is seeking. If he's seeking to amend the Constitution without a referendum, I think the best thing he should have done is to go out there and collect 1 million signatures, go through the same process that the BPA process has taken, and even the Punguza Mzigo took. But on this one, I am keen to see that at least we try and listen to that investigator. Put ourselves in the shoes of the CID department on the challenges that they go through. And some of those challenges are brought by us politicians, depending on which side of the divide you are in. If you're in government, you make it very difficult for an accused person. Sometimes you go in, even us as politicians, we've been arrested, detained, and then they work hard to try and bring you within 24 hours, but they arrest you on a Friday. So if some of those issues are issues that we need to address, then we do so. And this petition now gives us an opportunity to address those issues. So, Mr. Speaker, I thank you, and I hope that we'll give justice and not condemn every petition that is brought before this House. Thank you, Mr. Speaker. Senator.
This matter of arrests and detentions is so important. I'm dismayed at how we are going into relevant issues of political shadow boxing. Mr. Speaker, as we speak, there are 2 young men arrested, found dead in Embu, and I'm sure the senator for Embu might have a statement around that. That's what we should be talking about. We can't start talking about, political issues. We have young people being arrested every day. Those 2 are dead. Families are mourning. Kenyans who are watching expect us, when we're talking about arrests and detentions, to seek justice for those people and not start political shadow boxing, which can be done elsewhere, Mr. Speaker. I ask you, Mr. Speaker, our standing orders are clear on the matter of relevance. Can we stay relevant to the issue of that petition, and then we move forward, and I hope there's a substantive statement, because we want to talk about what is concerning Kenyans right now, which is what happens when these arrests and detentions are done against the law that we have, Mr. Speaker. So I'm just asking for relevance, Mr. Speaker. There are many opportunities for us to do politics, and we can do it elsewhere. But right now, let us focus on what is key in the mind of Kenyans, Mr. Speaker. So Mr. Speaker, without anticipating debate, because I've not seen any statement, the matter of those young boys, one from Embu Technical, another one, I think, also in university, a 4th year, who were arrested and found dead. And it is, you cannot anticipate debate. And it is, and Mr. Speaker, it is not the only case that has happened. There are many similar incidents in Nairobi. Please let us go to that discussion, Mr. Speaker, if that's a discussion. But the matter, the relevant, or rather the subject matter right now, is about petitions. It is not about who is in the outside onion of the government, who is inside, who is, I don't know, whose brother. That, Mr. Speaker, is neither here nor there.